Hello, my name is Michael Schwartz. I am a law professor at Syracuse University, College of Law in New York. And this video clip is the first of 4 topics. This topic is about anti-discrimination litigation. If a plaintiff's claim is unclear, it is up to the defendant to make a motion. Usually, a motion to dismiss for failure to state a claim. If a pleading is so vague or ambiguous that the defendant cannot reasonably prepare a response, he can move for a more definite statement. The court can sua sponte on its own order the plaintiff to amend its pleading. If the defendant is guilty of discrimination, the plaintiff can ask for remedies to correct the discrimination. There are 2 ways of determining what a defendant will need to do to settle the lawsuit. One is through mediation, an alternative dispute resolution mechanism. Many cases are settled through mediation. Also, the court can decide what remedies it will impose on the defendant if the plaintiff wins the lawsuit. American courts have great discretion in issuing an injunction to end the defendant's discriminatory policy or practice. The standard is, quote, abuse of discretion, end quote, which occurs when the trial court makes a ruling that is arbitrary or absurd. This does not happen very often. Courts will determine the remedy, not the defendant. That is why defendants try to settle the case outside court, because that allows them a role in determining the remedy. Failure by the defendant to remedy the discrimination does not mean the plaintiff has lost its lawsuit. It means the plaintiff has to file a motion to compel the defendant to provide the remedy that the plaintiff won in court. Court action to remedy discrimination proven at trial varies according to the facts of the case, including what remedies the plaintiff seeks. Remedies include requiring the defendant to provide reasonable accommodations and alter its policies and practices to prevent discrimination. American courts have great power to stop discrimination. The main rule for injunctions and restraining orders in the United States is Rule 65 of the Federal Rules of Civil Procedure. The United States Department of Justice often settles anti-discrimination litigation through settlement agreements. Both Rule 65 and DOJ agreements are on the internet. Courts can grant 3 types of injunctive relief: preliminary, temporary, and permanent. A preliminary injunction preserves the relative positions of all parties until a trial on the merits is held, and the movement bears the burden of persuasion that a preliminary injunction is appropriate. A temporary injunction is similar to a preliminary injunction, and then it preserves the status quo until a hearing for a preliminary injunction can be held. A permanent injunction settles the dispute after a hearing or a trial on the merits. An order for injunctive relief grants some or all requested relief to a favored party by directing or forbidding the opposing party to act, with consequences enforceable by contempt power. To obtain injunctive relief, a party must prove that they have suffered irreparable harm and that there are no legal remedies for that harm. Pursuant to Rule 65D of the Federal Rules of Civil Procedure, every order granting an injunction and every restraining order must state the reasons why it was issued, state its terms specifically, and describe in reasonable detail the act or acts restrained or required. A simple or abstract order would not be upheld on appeal. An American court would not allow the defendant to choose the remedy. If a defendant refuses to obey the court's order, Rule 70 of the Federal Rules of Civil Procedure states that if a court order requires a party to provide a remedy and that party fails to comply with the order, quote, the court may order the act to be done at the disobedient party's expense by another person appointed by the court, end quote. In the United States, the defendant does not have the luxury of voluntarily choosing the remedy. If the plaintiff proves the defendant's guilt, he is entitled to relief. Mediation is actively used in litigation in the United States. Mediation is a process in which an impartial third party helps the parties settle their differences without going to trial. Mediation is voluntary, but a judge can order parties to try mediation before pursuing a lawsuit. A judge may not impose a settlement based on the mediation if the parties fail to resolve their issues. The advantages of mediation are savings in time and money. The parties have full control, including the choice of a mediator. Mediators help parties communicate with each other, ensuring each side understands the other side's position. Mediators may suggest settlement terms based on the parties' goals, but they cannot enforce terms. Mediation is faster and less expensive than lawsuits. The parties may reach an agreement within hours or days. In contrast, lawsuits can take years to resolve and incur high costs. The parties share the cost of mediation. However, there is no guarantee that mediation will completely prevent animosity between the parties, especially if the mediation fails. Mediation probably won't work if one party feels strongly about their position or has been greatly harmed and feels she deserves more damages than the other is willing to pay. Judges may act as mediators, but, like all mediators, judge mediators have no authority over the party's decision to settle or not to settle. Generally, judges are not involved in mediation. All they hear is whether mediation resulted in settlement or not. If a judge is also a mediator, he or she surely can propose ideas for settlement. Anything said in mediation sessions is confidential. If mediation fails, the parties' positions cannot be used against them at trial. A mediation agreement does not develop precedent. When parties resolve their disputes in mediation, they sign agreements that spell out the agreed upon terms. Signed agreements are treated as contracts and thus can be enforced through a lawsuit for breach of contract. Also, if a court orders mediation and the parties reach an agreement, that agreement is considered a court judgment. The plaintiff's lawyer is dependent on the client to furnish information about the injunction's performance. Usually, a settlement reached by mediation or after a trial verdict favoring the plaintiff will have a provision for supervision of the defendant's performance. In the event the defendant fails to correct discrimination, Rule 70 of the Federal Rules of Civil Procedure allows a court to, quote, order the act to be done at the disobedient party's expense by another person appointed to the court. When done, the act has the same effect as if done by the party, end quote. This rule also allows the court to hold the disobedient party in contempt. Rule 42 of the Federal Rules of Criminal Procedure allows a court to punish, quote, criminal contempt of court, end quote. The federal rules are on the internet. Criminal contempt of court is a criminal charge which is employed to punish behavior that interferes with the proceedings or orders of a court. Criminal indirect contempt of court is based on violation of a court order, whereas criminal direct contempt of court is based on conduct at court proceedings. Defendants charged with criminal contempt are afforded all the usual privileges of other criminal defendants, like the right to a trial by jury, to examine and to call witnesses, and to testify on one's own behalf. If the United States Department of Justice is the plaintiff, a violation of the settlement will result in enforcement, including penalties. Settlement by mediation or a trial verdict in favor of the private plaintiff usually involves a provision for enforcement by the trial judge. The plaintiff will have to file a new lawsuit to attack the repeated discrimination.